Hello, everybody. Welcome. My name is Paula Price. I'm with the People's Law School, and today's webinar is Making a Will in British Columbia, Town Hall Q&A. In terms of what you can expect today, we've got 60 minutes together. We're going to be providing answers to questions. The questions came in from guests who are attending today. We are going to be providing legal information, not legal advice. And if you'd like more information, or if what you're looking for is the law as it applies to your specific set of facts, we would encourage you to reach out to one of our speakers, and you'll see their contact information is on the screen. And before we get started and introduce our speakers, we wanted to acknowledge that the land on which the People's Team is gathered is the territory of the unceded territory of the Coast Salish peoples, made up of the Musqueam First Nation, the Squamish Nation, and the Tsleil-Waututh Nation. We would also like to acknowledge the financial support of the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation. And with that, we will introduce our guest speakers. They are all amazing. They were here last year during Make a Will Week as well. They did the original Make a Will webinar, and if you haven't seen it, I highly encourage you to watch it. It's a wonderful resource. We have lawyer Michael Scott. He is a lawyer in private practice. He practices at Clark Wilson in Vancouver, British Columbia, and he has an estates and planning practice. Welcome back, Michael.
Thanks, Paula.
We also have David Watts, and David Watts is a notary public. He has a practice in Vancouver as well. He was here last year as well, and we're excited to have him back. Welcome, David.
Thank you, Paula. Good morning, everyone.
Thank you. And last but not least, we're excited to have Brandy Stocks back as well. She was here during Make a Will Week. She provides a unique perspective. She works in the Child and Youth Services Department of the Public Guardian and Trustee, and brings a unique perspective to the estate planning exercise. And so thank you so much, Brandy, for being here today. Welcome.
Thanks so much, Paula.
And thank you. And so with that, we're going to jump into our first question, which is for Brandy. Brandy, at what age or life stage do you recommend creating your first will?
Thanks, Paula. So the underlying question here is, why do you want to make a will? You make a will when you want to say over what happens when you die. So you can be clear about who and who does not get your assets, your house, your bank accounts, your priceless country music record collection. A will also gives you the opportunity to leave your money to charity and helps the people who outlive you. They'll know that they're acting on your wishes, and having a will helps save your family members significant time, effort, and money in dealing with your assets. So no matter the life stage, you should make a will if you have assets and if you care what happens to them. Another main reason to make a will is so you can identify who you want to care for your children should you die while they are minors. Otherwise, your children may not end up with a guardian you would have chosen. In your will, you can also name a trustee for your kids while they're minors. That's the person who will hold and manage the assets you leave them until they're adults. Without a will, the public guardian and trustee would become the default trustee. So to sum up my answer, I think you should make a will if you have children or if you have assets. In addition, anytime a major life event happens, your parents die, you get divorced, you get remarried, you were the lucky ticket holder of last week's $70 million lottery. Anytime a major life event like that happens, you should either make a will or review your will to ensure that it's still appropriate and adequate. And one more fun fact, in general, you need to be at least 16 years old to make a will in BC.
Beautiful. Thank you so much, Brandy. That is so helpful. The next question is for you, Michael. What happens to my property if I don't make a will? I'm married and we don't have kids. Will everything go to my husband?
Thanks, Paula. And I just will say quickly, thanks for having us back again for round two. So this is great.
Pleasure.
Thanks for the
Such a
People's
pleasure.
Law School for organizing this for us. That's a good follow-up question to the one Brandy answered, and that was a really good answer, Brandy. That's a I'm gonna have to I might steal that. So if somebody dies and they don't have a will, then the legislation, and we're assuming that we're dealing with BC situations here. The legislation in BC kicks in to determine what happens with the estate. And the legislation is the Wills, Estate Succession Act, and we call it WESA. And WESA says there's kind of a next of kin order that would apply. In this particular situation, if someone's passed away, they're married and have no kids, then everything would go to the surviving spouse.
Super. Thank you so much, Michael. And thank you for mentioning the WESA. I have a feeling that might come up again in today's conversation. The next question is for you, David. Can we use a self-help kit to make our will? How legitimate is a will made without a lawyer or a notary?
Thank you, Paula. So there are a number of options for people as to how they might go about making a will. And a lot of people, are wanting to try the do-it-yourself or self-help route. There are kits you can get at Staples. There's online tools and so on. So what my comment on those resources is this. I think if you find the right package, being one for British Columbia, and you follow the instructions thoroughly and completely, then you should be all right using one of these kits. But what we find often is people may have the wrong, a kit for the wrong jurisdiction, or they don't read the whole thing. So what, it's a good starting point a lot of times. We often meet with people who have started a will or started the process using a do-it-yourself kit. And we use that as a kind of a start of our process, and then we continue to sign the wills. Second part of the question is, how legitimate is a will made without a notary or a lawyer? In British Columbia, there's no magic about a notary or a lawyer signing the will. It doesn't need to be notarized or executed under seal. It does need to be witnessed by two people who are not in the will, who are not beneficiaries or spouses of beneficiaries or executors. So that's something that's in the legislation, and it doesn't need to be notarized, but so that works out okay for the self-help kits.
Super. Thank you so much, David. That's such a great answer.
Thank you.
The next question is one that we receive quite a bit, which is, to advance the slide, which is, what is the average cost of a simple will? And David, if you wouldn't mind sharing your thoughts on that.
Sure. So it's kind of an interesting question, because average cost and simple will are, it kind of varies a little bit. What I would say, when we meet with clients, an average cost, I guess, a starting cost, taxes plus disbursements and our fees, probably about $500 for an individual. For a couple, maybe it's getting up to $800. And we're looking at, a couple of hours. Would have a first meeting with a client to discover everything. Then we've got some time to prepare the documents, send them back for review, and then make sure everything is the way we want it to be, and then we get around to signing it. So there is some time involved in even for a simple will to record thoughts accurately and properly and in the right format. So, the cost often, if it's simple or if it's a bit more complex, it's similar, because we're still spending a similar amount of time. There are times that the cost goes up based on complexity, or a lot of times the size of the estate, or depending on trusts that a client might want. And those are the costs. In our office, I think you have to call your local lawyer or notary for a quote from their office. And I would also just keep that as that's a simple will. And a lot of times we'll meet with a client and they've got a situation that I'll call more complex, and we'll often then refer to a lawyer who's got more appropriate tools to handle a more complex will situation.
Thank you so much, David. That's really helpful. I think also highlighting the amount of time and that it's an exercise of bringing the information to the notary or to the lawyer, that's part of the procedure. Michael, do you have any comments on the cost of the average cost of a simple will?
I could speak to it. It would be, so when we do it, yeah, the cost is a little more than what David is saying, and I think we're spending, David may be doing this as well, but we spend a little bit more time on that, and we're not just looking at drafting the will, we're looking at what kinds of assets you have, how you own them, looking at the situation and trying to make sure that the ownership of your assets is going to be appropriate for the way that you structure your will. You want to make sure that those, your asset ownership and your will are in sync, and so that the way that your will is set up is going to, or the way that your assets are owned, they will flow the way that you want them to flow, whether it's through the will or outside of the will. And so we're looking at the big picture there, and trying to give you advice around that, both from a legal perspective as well as from a tax perspective. And so that's kind of built into it. So yeah, I mean, doing a simple will, it could be about $1,000 for one, and so for a couple, it could be around $2,000. But generally, and I'm sure David would find the same for this, when people are doing their wills, they're also doing powers of attorney and healthcare representation agreements at the same time. So it kind of comes as a package deal. And so it's not often that people come to me and they just want to do the will. More often, they're coming and they want to do the full package. And to do that full package for a single, it might be $1,700, and then plus taxes and disbursements. And for a couple, it might be $2,200-$2,300 plus taxes and disbursements for the full package.
Super. Thank you so much, Michael. That's really helpful, Michael and David both. So our next question is also a question that is quite a common one that we see. I'm having a difficult time finding an executor. One possible choice is asking for reimbursement. What's the usual amount of reimbursement for being an executor? And David, if you wouldn't mind answering this, that would be great.
Sure, thank you. Yeah, finding an executor can be a challenge, especially when people understand what a big job it is. And I think that looking at people who you would want to look for to be an executor, I mean, first off, I would always look at beneficiaries because they're going to sort of set the pace of things. And if one of them can do it, that would be a good choice. But I would always look at somebody who's somebody who's trustworthy, who's somebody who's relatively organized, resourceful. Those are good qualities for people who would be an executor. In terms of reimbursement, the Estates Administration component of WESA sets an executor fee at, or maximum executor fee at 5% of the value of an estate, and it's up to. So that's a one end of the spectrum, and I think that people can charge as an executor whatever is reasonable, up to that. Now another, I guess, option is a professional executor. There are some trust companies that offer that service. There's some other professionals. We offer that service in some fairly select situations, usually as an option of last resort. But we have a fee agreement, and it's sort of based on the fee in the State Administration Act amount, but ours is a little bit less, but it sets out what we do. We also have a minimum on ours. An estate is a lot of work. It's probably a couple of years of back and forth with executors and with beneficiaries and CRA and accountants and the probate registry and everything else. And this is, I just want to be clear, this isn't doing the probate work. This is just acting as the executor. So it's sometimes a professional executor is not a bad option. It keeps things arm's length with the beneficiaries. Sometimes people's kids don't get along or trust each other, or there's different sort of dynamics that appear or reappear in these situations that people would just rather avoid. So,
super. Thank you so much. Thank you so much, David. It's great to have ideas and suggestions on what to do in that situation. on a somewhat related note, Michael, if you don't have someone in BC to be your executor, can you appoint a person who lives in another part of Canada or the US? And if so, how difficult would it be for them to handle the estate?
Right. So before I answer that, I will just say, just because I was watching the chat and I saw a question pop up just asking, what is an executor? So if we just kind of step back and an executor is the person that you would be appointing through your will to manage your estate and dispose of your asset, pay out your taxes and debts, and dispose of your assets pursuant to your wishes that you've laid out in your will. And so it's really, it's a big job. It takes a couple of years. Oftentimes they have to go through a probate process to certify their appointment. And then it's a matter of gathering assets, paying taxes, and making distributions. And there are many laws and rules in terms of how they're to operate and carry out their duties. So that's because it's a big job. That's why, you know, some professionals do it, and why people appoint trust companies to do it. Rather than putting it on an individual. So that's I hope that somewhat answers that question. Now, can someone appoint a person that's outside of Canada? So the simple answer is yes. I mean, you really can appoint whoever you want to act as an executor of your estate. If you are appointing someone, the kind of where the heart of that question really comes to the residency of the estate. So if you're appointing someone that is resident of Canada, then on your death, your estate maintains its Canadian residency. The residency is really primarily based upon where the control and management is occurring, where those decisions are being made. And so where those decisions are made by the executor. So if the executor is a Canadian resident, then in effect, your estate is a Canadian resident. But if your executor is outside of Canada, then your estate can become a non-resident estate, which changes how the taxes would apply for your assets following your passing. So there's still a taxes on death, which would be on your final tax return. But then the estate would have taxes on the assets on any income going forward, and the rules around that become based on non-residency rather than on Canadian residency. There could also be withholdings that kick in if there's certain types of capital property. So real estate, if the estate holds real estate, and the executor is a non-resident, then on a sale of the property, there's a withholding process where some money has to be held back pending the executor applying for non-resident clearance with CRA. And there's no additional tax on it. It's just really a filing and some extra work that the executor needs to run through, typically with an accountant. But yeah, so generally the answer is yes, you can appoint anyone anywhere. Sometimes there is no one else, the appropriate person to act is someone that's outside of Canada, and that's okay. With respect to the US, still the same kind of non-resident rules if it's someone that's in the US. The only kind of kicker is that the tax rules in the US are very different than they are in Canada. And so the US have rules which say that where you have control over assets, then you've got an obligation to disclose those assets to the IRS. So somebody that's acting as an executor technically has control over assets, even though they're not in the US, even if they're in Canada, and would have a duty to report those assets to the IRS. There's no additional tax on it, but there is certainly a reporting that would need to be done. And in addition, there could be other tax filings that need to be done in the US for any income that the estate would be earning, because now it could be a US resident estate where there are tax filings that need to be done there and taxes paid. And there are treaties between Canada and the US to address that, but sometimes there can be a difference in the way that the taxes work, and could be taxes owing in one jurisdiction and not the other. So you have to be very careful when you're doing appointing someone in the US to act as an executor. And typically we do that where there really is no one else, or we do it where you could have that person, but then have a Canadian option as an alternate where if you passed away, you've got your US resident and citizen executor, but then they can consider the situation at the given time and talk with professionals. And if the advice that they're getting is to resign or renounce, then they can step down as executor and then leave it with the next in line, who would be a Canadian option, and then to maintain the Canadian residency status of the estate.
Super. Thank you so much, Michael. That is really, really helpful. Our next question is for you, David. If I've named a beneficiary in a registered retirement plan, does it need to be included in the will as well?
No. I'll go on a little bit. So the idea here is there's some plans like a RRSP or TFSA, you can designate a beneficiary so that within the plan, within that account, there's already succession built in. And there's sometimes some tax benefit, especially with RRSPs to spouses, where the money doesn't have to become deregistered and taxes paid. So in those senses, that account just flows directly. It doesn't need to be included in the will. One of the purposes of the will is to, to give authority as to transfer assets, as well as to identify who gets them. But if you've already done that with the account holder, bank or financial institution, and you've identified who it is, then it doesn't need to be in the will.
Super. Thank you so much, David. Short and sweet. This next question is for you, Michael. What is the best way to leave money to charity? What kind of tax relief might result if I leave money to charity?
So I think it would really be circumstantial in terms of, what is the best way to leave money to charity. There isn't really a best way. There's, you have to review your situation and then consider the options that are available. So I can speak to the number of different ways that you can donate to charity. So one is you can leave a cash gift through your will. So within your will, you could set a fixed amount to go to a charity, and that works. Option two would be you could leave a percentage amount. So you could leave a residual proportion of your estate to a charity. And so those would both be gifts through your will, where the charity would be a beneficiary of your estate. Other options available. So David just spoke about, I think it was RSPs, but you can name charities as designated beneficiaries on registered accounts. So you could, in kind of looking at your the tax planning component of your estate plan, sometimes it makes sense to name a charity as a designated beneficiary of an RSP or RIF or life insurance policy, or TFSA for that matter. Oftentimes the charities like that because they can then receive the donation outside of your estate. So they can receive the money right away. They don't have to await the executor to go through the full administration process before they get to a point where they can distribute, which oftentimes takes a matter of months. So it can take 6 to 8 months and sometimes longer to hit a point where you can distribute. So charities can receive through a beneficial designation right away. They do get the tax. So however you set that up as part of your estate plan, the charity would provide a donation receipt, which would go to the estate. And provided the estate qualifies as a graduated rate estate, I'm not going to go into too much detail about that, but generally most estates would qualify as that. But it allows for a lot of flexibility in terms of where that donation receipt can be applied. So whether it's into past tax years, a couple of years past, the terminal tax year, which is the final tax year, and return, which would have the biggest tax hit because there's a deemed disposition of taxes that applies on death, and including any years forward for the next, I think it's 5 years. So if there are assets within the estate that are generating income, then the donation receipt can be used against those taxes as well. So there's lots of flexibility. There is a good benefit. It's certainly a tool that we have discussions with clients about as part of their tax planning for their estates.
Super. Thank you very much, Michael. This next question is for you, David. Will my parents or my children be liable to assume my debts when I die?
That's a good question, and that's quite a common question, actually. If you've co-signed for some debt, then I think the answer is pretty clear. It's yes. But most, just because you're related to someone and they die, you're not automatically on the hook for their debts. If you're a beneficiary of an estate and the estate owes money, those bills are all going to have to get settled before you're paid. But if you have an estate that's insolvent and you're related to the person who's passed away, you're not liable to pay those accounts. Now, that's not to say that creditors might not try. I have heard situations where people come after family members to try to collect on debts of people who've passed away. But unless, like I said, unless someone's co-signed or you are actually a borrower in some capacity, you don't have that liability.
Super. Thank you so much for clarifying that, David. That's really interesting. It's really helpful. The next question is for you, Michael.
Okay.
And my beneficiaries live in the US and are US citizens. Will they be taxed on the condo and savings I left for them in my will?
Right. So this is fairly common as well. I mean, there are lots of us in Canada have family members that move out to the US and live in the US. It's a difficult question for me to answer. I can speak to it very generally, but typical lawyer answer, it depends on more detail. Generally speaking, if parents have passed and the asset, they're Canadians and the assets are in Canada, and it's just one of the beneficiaries is a US citizen or resident, then it's a Canadian estate. So any taxes would really just be the parents' taxes on death, which would be a deemed disposition of any capital assets. So there'd be capital gains tax, which would be realized and then reported on their final tax return. And of course, any income tax that would be owing. So that would be paid ultimately out of the estate within Canada. So all of the parents' taxes are paid in Canada. And then the executor, who's dealing with all of this, would take the balance and then affect distributions. There can be, similar to what we were talking about before with non-resident executors, there can be withholdings that are required in Canada before distributing to a non-resident beneficiary, and then a clearance certificate that would need to be applied for and obtained by the beneficiary before they could receive the funds. But on the US side, there are no taxes to receive an inheritance that I'm aware of. But what they would have to do is the IRS like to know what everybody has. And so that beneficiary would be obligated to file a report with the IRS to confirm that they've now received more money, they have more assets. And so it would be on record with IRS, even though there's no tax. There is the reporting that would need to be done. There are specialists, cross-border specialists that work in this area, and depending on the specifics of the situation, oftentimes we rely on either cross-border accountants or cross-border lawyers to jump in on this and weigh in.
Super. Thank you so much, Michael. That is really helpful. Our next question is for you, David. If I own real estate in another province, should I have a separate will for that province?
Great question and common question. And the answer is notaries answer this way too, Michael. It depends. And really, it depends on the jurisdiction and what their laws are around property dispositions or even formatting of the wills. So what a lot of times it probably will work. But what I always encourage people is, if they own assets in another jurisdiction and you want a will to work in that jurisdiction, if if you've got one here, have it vetted there, and vice versa. If you've done a will in, in Quebec or in Ontario or anywhere, and you want to know if it'll work here, get someone to have a look at it. There is a process here in British Columbia when it's called resealing a will. And basically the idea is that you can use the will and look at the assets that are domiciled here in British Columbia, and you pay the probate fee on that asset, and then the registry sort of gives their blessing that that asset can be dealt with using that will. So I guess two-part answer, probably it depends, and get it checked in that jurisdiction.
Super. Thank you very much, David. Brandy, this next question is for you. Are we allowed to name a guardian for our kids who is not a Canadian and or lives in another province?
Thanks, Paula. This is a good question too. So first of all, as I mentioned earlier, in a will, you can appoint a guardian for your children. And a guardian is the person you appoint to make the day-to-day decisions for your minor children. So including decisions about their healthcare, their living arrangements, their education, and their upbringing. When choosing a guardian, obviously, it should be someone that you trust implicitly to take care of your children and to act in their best interests. It is open to you to name any guardian for your kids, including one who lives in another province or another country or who is not Canadian. However, there are some considerations that would go into that decision. So first, obviously, the move away from their home, their friends, and their school would have a huge impact on your kids, may involve cultural changes and language changes, and could be quite traumatic, particularly after having just lost a parent. So you may want to consider guardians who will maintain the most consistency in your children's lives if possible. In addition, you should think about and get advice on the tax implications that could arise if children move outside of Canada and a Canadian resident trust has been established for their benefit under the parent's will. And this echoes what Michael was saying earlier about a non-resident executor. This may include withholding tax as well as local tax for the kids in their new jurisdiction. And there would be further significant tax implications if the named trustee of the children's trust is also a non-resident of Canada. The trust may become a non-resident trust, to echo Michael again, without proper planning in place. Having children move outside the jurisdiction or naming a non-resident trustee could create pretty significant unintended tax consequences. So I'd strongly recommend getting legal and accounting advice if this is something that you're considering.
Super. Thank you so much, Brandy. Brandy, we have another question for you. How old do kids need to be to not need a trustee?
All right. I will answer. I see another question on the screen as well.
Yeah.
I'll answer both of these questions.
Sure, if there's more convenient, absolutely.
Yeah. So in a will, in addition to appointing a guardian for your children, you can also appoint a trustee to hold and manage the money that you're leaving to your children in your will. The guardian and the trustee are often the same person, but they don't have to be. So to answer this first question, in BC, the age of majority is 19. So until kids turn 19, they require a trustee for their funds that they are beneficiary of under a will. With respect to the second question, can an older child, age 21, be a trustee for a younger sibling, age 17? So just like with guardians, it is open to parents to choose any trustee, including an adult sibling of a minor child. And, it really would be a judgment call as to the age of the minor child, the maturity of a proposed younger trustee. I mean, the bottom line is, to echo what I think David said earlier, you need to choose someone who will act in your minor child's best interests. The age issue can go the other way as well. Choosing your 75, 80-year-old father to be the trustee for your 1-year-old in your will may not be the wisest choice. Although in any event, naming an alternate trustee to act if your first named trustee is no longer able to do so would be prudent as well. Some other things to consider when appointing a guardian and a trustee are, if you're appointing a couple to be a guardian, think about what would happen on separation if they were to separate. Think about the relationship between the proposed guardian and the proposed trustee if they're separate people. Think about possible compensation for the guardian to recognize their efforts. And of course, most importantly, think about, the values, the emotional and financial capabilities, and the willingness of any appointed guardian. I think regardless of where the guardian or trustee resides or how old they are, parents should make a real effort to ensure that the proposed guardian and trustee is willing to act. And I also think it will be wise for parents to continue to confirm this every few years, that the guardianship and trustee appointments they have made are still appropriate. I think estate planning is essential to make sure you're considering all the appropriate factors when you're making these important decisions.
Thank you so much, Brandy. That is really, really helpful. This next question is for you, Michael. My mother-in-law told me it's impossible to write your children out of a will. Is that true?
The simple answer is it's false. You can do whatever you want with your will. I mean, if you want to keep, exclude all of your kids, you could do that. However, we have a provision in BC called wills variation, which is embedded within WESA, our wills and estates legislation, which says that your spouse and your biological and adopted children have certain rights to your estate, where if any of them felt that they've been inadequately provided for through your will, then they can apply to the court to claim to have the will varied or amended to give them whatever they consider to be a fair share. And then ultimately a judge would look at it, look at the situation as a whole and consider if it's appropriate to vary the will to build them in for a share. And so if you are planning to exclude your kids to some level, or any one of your kids from your will, then you might want to get proper advice around what that means, what your options would be, because there can be options to protect your estate and to protect your wishes. For example, you could look to move assets outside of your estate. So assets within your estate are governed by your will. And so as a result, any change to the will impact those assets and what happens to them. But you can also settle trusts and move assets outside of your estate and into trusts. And then they're no longer part of your estate. So they don't go through your will. So they're protected to a certain degree from wills variation. Because you can't make wills variation claims on a trust. It's only a claim that you can make on a will. And similarly, people will look to use things like beneficial designations. So David was talking about this earlier, but yeah, RRSPs and TFSAs and RIFs, life insurance, you can name beneficiaries directly on those accounts. And the effect of that is that those accounts then would go directly to those beneficiaries outside of your estate. You do have to be careful there as well, because there are tricky laws around how naming your kids works on registered accounts. So there is a law that would say that those accounts would still be part of your estate. So sometimes you need to be crystal clear as to your intentions when you're naming your kids as beneficiaries on those accounts as a means to get it out of your estate.
Super. Thank you so much, Michael. And I'll just note for members of the audience that your colleagues at Clark Wilson, Amy Mortimer and Zachary Rogers, spoke last year about contesting a will or challenging a will. And this was one of the topics that came up. So that's another resource that's available. It's a recorded webinar on the People's Law School website. So that's another source of information about challenges to a will based on the distribution or exclusion of children or spouses. So with that, the next question is for you, David. If one of my children is contributing to my living expenses, I'm sorry, I should probably show everybody the slide. If one of my children is contributing to my living expenses, how can that child be compensated in the will for the amount that they've paid to me?
I'm on Zoom. Sorry. So there's a couple of ways of dealing with this. I mean, what I would always encourage people to do is whatever, if they're contributing expenses, write it down. Keep records, whether it's receipts of everything or a spreadsheet, and So you have a record of everything. And one of the instructions within a will is that the executor pay all liabilities. And so I think that those living expenses could be provided to an executor to pay. I think another way is you could write something into the will, that specifically says, my son has been paying such and such, and that they be compensated. That's a bit more of a moving number and a bit more variable. So I usually like certainty. I think that the other thing is you can leave an instruction that doesn't necessarily have to be in your will. You can leave a letter to your executor or write a memo that would coexist with your will that basically says, hey, this is, my son or my daughter's been paying, $500 towards my rent each month for the last 15 years, and I'd like them to be, repaid for that. And so a memo like that, while not in the will, is something that's, evidence of your intention that it be, brought current. And so that's another way to deal with it. And just a quick comment mention, I guess, would be, sometimes there are other ways of accessing funds, whether with a reverse mortgage or sometimes power of attorney can help in different ways. So there are various ways of doing things, and I think this would be part of the conversation that you have with your lawyer or your notary when you go to do your will, and just say, hey, this is what the situation is. What do you recommend? And a lot of times we will have seen something like that and be able to offer some ideas.
Super. Thank you very much, David. Another question for you, David. How often should you be updating your will?
Probably every couple of months.
If you have a very exciting life.
No, we write a will so that you shouldn't need to update it unless there's some sort of major life change. And even, we'll build in alternate beneficiaries, alternate guardians, alternate trustees, and executors. So, there can be a few things happen before a will must be changed. But often we see changes when, somebody is, something that's in the will, you don't want it there anymore. Whether there's a marital breakdown or a breakdown of relationship with some of maybe guardians, or people fall out of favor in one way or other, that, favorite nephew stopped visiting you and you don't want to leave them in your will anymore. It might sound funny, but it happens all the time. You can update it whenever you want, really is one side of the spectrum, but when it's written properly, you shouldn't have to update it just because time has passed or you've moved and your address is different, or one of your kids is married and now has a new last name. Those are things that don't require it be updated. Often what I'll say to clients, who come in for their first wills, I say, look, you're doing your first wills, you're probably naming guardians for your kids. Look at this again in 25 years, because then you're going to be probably naming your kids as your executors and trustees, and that's going to be another time you look at things. So those, and then anything in between. So when you'll know when you need to update it.
Super. Thank you very much, David. This next question is for you, Brandy. I made a will in 1990, but the executors and beneficiaries I named are no longer options. Do I need to make a law firm or the public guardian and trustee my executor?
Okay. So first, as we've mentioned today, sometimes a will names an alternate executor. If the first named executor passes away before the will maker, then the alternate executor can step into the role. So check to see if you named an alternate executor in your will who's still available. So if that's not the case, you didn't name an alternate executor, and now your named executor has passed away or is incapable of acting, then it would be preferable for you to draft a new will or a codicil appointing a new executor. So ideally, and I think David touched on this earlier, ideally you want to appoint someone you know and trust, a family member or a friend or one of your beneficiaries. And to echo what David said earlier about professional trustees, So appointing a lawyer or a notary. One thing to consider is that appointing a person like that is really the same as appointing any other person, with the same risks that they may predecease you or may otherwise become unable or unwilling to act. In my experience, many lawyers will not agree to become executor of a client's estate, just because of the amount of work that it is. Another option is appointing a trust company as executor, and this would involve certain fees, but you should consider the value and the experience they would add, as well as the fact that it would be very unlikely that they would become available to act like an individual executor. And alternatively, the public guardian and trustee, the PGT, may agree to be named as the executor in a will, but they must be consulted beforehand. The PGT would review the draft will prior to execution. And once the will is executed, the PGT would hold on either to the original or a copy of the will. And when acting as executor under a will, the PGT has the same powers and duties as any other executor, and also charges statutorily mandated fees and commissions to act as executor. So if you're considering appointing the PGT as executor, contact the PGT's estate and personal trust services to discuss whether the PGT would be an appropriate choice and whether the PGT would agree to act as executor of your will. And I think at the bottom of that slide is the contact information for that department.
Exactly. Thank you so much, Brandy. The next question is for you, David. We've recently moved to BC and we have wills. Do we need to update them here?
Thank you, Paula. That's sort of similar to the question that we talked about earlier. And again, I'd say it depends. If you've done a will in another jurisdiction that, meets the technical requirements of a will here, then I'd say no. If it doesn't, then yes. But what I would recommend is, it doesn't hurt to book some time to review them with your, with your legal provider. And, we've a number of times, we've had this question and people come in and we look at it and we discover it's not just one thing. It's not just the fact that they've moved. There's something in the will. They're like, yeah, actually, we'd like to change that, or we want to update this, or they haven't done power of attorneys or representation agreements that are going to work in BC. So a lot of times there's we find something to do when we get together, or maybe we don't. Which getting to that answer is just as valuable, I would say. So you've got that certainty and confidence that you're taken care of.
Super. Thank you so much, David. And our next question is for you, Michael. And Michael, I'm just going to note this is the last of our prepared questions. So after I read the question, I'm going to unshare my screen so I can see the live questions coming through, in case anyone's wondering what's happening there. So Michael, if you want to add to the will, but don't go to the lawyer to revise your existing will, what makes the new addition legitimate?
Well, I suppose I don't know. I hope that I'm understanding the question properly. But if somebody came to me and they had a will from another lawyer, they didn't want to go back to that lawyer, or that lawyer retired, and they want to make a change, I can't. And I don't know what David does, but maybe the same. I can't make a simple change to the previous will, because that's done by someone else, by a different professional. I would have to help them by revoking that old will in its entirety and then signing a fresh new one and in our template, or by just drafting up a codicil, which is an addendum to a will, to add the piece that they want to add. And how to make it valid it just needs to meet the signing requirements within BC, which is, as David talked about this earlier. But yeah, it's just having two witnesses. They don't need to be lawyers or notaries, but just needs to be two witnesses, and those witnesses, for the most part, need to be completely independent from the will maker. So it shouldn't be someone that's related or named in the will as an executor or a beneficiary or a spouse of any of those people. So yeah, I would think codicil would be one route, or just redoing the will in its entirety. And as David said, oftentimes, people will look at one thing that they want to change, and then they speak with us, and it turns out there are more than just one thing that need to be changed. And so at that stage, doing a bunch of changes, maybe it just makes more sense to revoke that old one and sign a fresh new one.
Super. Thank you, Michael. And I'm now looking at the Q&A that have just come in. And I'm going to start with this one. It has 13 upvotes. It's a popular question. And Michael, perhaps you can answer this. Do you have to list every single asset in your will, or can you just say that all your assets get split evenly between your children?
So it's the latter. You don't have any obligation to list your assets within your will. If you have certain things that you wanted to go to certain individuals, then you would probably want to list those specifically. But generally, I mean, for a straightforward will, you don't have to list your assets, and I wouldn't recommend it, because if you sign your will today to apply to your worldwide assets, and then just saying that your estate, which would be those assets, goes equally between these people, or whatever it is you want to do, that's fine. And then if you update, if you sell those assets and buy new assets, then it doesn't force you to change your will. Whereas if you listed all of your assets, and then some of them are gone, and you've got new ones, and you'd be constantly making changes to your will to keep it up to date. It is easier it's more about the ownership. So it's, how do you own those assets? If you own them personally, then they're going to go through your estate. They're going to go through your estate, and then you can just say, my estate goes equally between these individuals, or however it is you want to do it. So.
Super. Thank you so much, Michael. I see there's a question here about what you do if you don't have somebody you can name as an executor. I think we've answered that question. Thank you for the question. Thank you for all of the questions that have been submitted today. We're going to skip over that one. I would recommend as a resource this webinar, but also the earlier webinar that we did last year during Make a Will Week. There's some more information about what to do if you don't know who to appoint as your executor. So moving to the next question, does a will need to be registered? Should it be registered? So I don't know, Michael, David, who'd like to take this one?
Sure, I can speak to that. A will doesn't need to be registered. Having said that, there is a wills registry in British Columbia, and as a matter of practice, we always register a will so that there is a record that it's been signed. It's going to identify you by name, birthplace, birth city, and then when a person passes away, you can do a search to make sure that you're actually dealing with the last will. So that's a registration of the will's existence and not what's in it. There are other, now we're getting into digital wills, electronic wills. The legislation now provides for that. So there are some digital tools for that. Sometimes for executors, there's a website called ReadyWhen that I know people, a lot of my colleagues are using as a way to save those digital documents and records of things. There's various other tools that sort of do similar things, but the registration, it's not necessary, but I think that if you've got different records of it, it's helpful.
Super. Thank you so much, David. We're going to move on to the next question. Are there different legal specifics that need to be taken when drafting an advanced healthcare directive, otherwise known as living will?
So a living will is an expression of your wishes. It's not based on any legislation. A healthcare directive is a document you'd often fill out with your doctor. We take a little bit of both of those documents, and we incorporate that into a representation agreement, which in British Columbia is sort of the legislative backed document. So probably a different workshop, different conversation, but we record all of that end of life advanced directive stuff in the representation agreement. So it's part of the same meeting, same conversation, different document.
Beautiful. And we do have a webinar about representation agreements coming up on November 23rd. So keep your eyes open for that if that's a topic that you're interested in. Thank you, David. We're getting really close to 1 o'clock, so I'm going to try to get in 1 or 2 more questions. Thank you everybody for your questions. We really appreciate them. Unfortunately, we won't be able to answer all of them. This one is, if your house is in joint tenancy, can you stipulate on your death your half of the spouse to go to your kids, or the joint tenancy supersedes your will?
So that question would take a long time to answer properly. But if you own your property jointly with spouse, sorry, if you own with spouse.
It says, if your house is in joint tenancy, can you stipulate on your death your half of the house goes to the kids, or the joint tenancy supersedes your will?
Okay. So very generally, the joint tenancy would supersede the will, but it depends on who you hold the property with jointly. If it's and it depends on what the intention of the individual is in adding that person as a joint tenant. If it's two spouses that purchased the property together and they took title as joint tenants, then it's likely that if one of them passed, then that person's interest would pass automatically to the survivor outside of the estate. So you wouldn't be able to dictate what happens with your interest through your will, because it doesn't go through your estate. If you put your spouse on the title because you were advised to do so, but you really purchased the property and pay the costs, or you put one of your kids on the title because you were advised to, then there is an argument that on your death, that child or that person that you put on title is holding the property in trust for your estate, in which case you would have the ability to dictate what happens with it through your will. But generally speaking, when you're adding people to title to real estate, you should be getting professional advice to make sure that you have things documented properly. That's from the legal side, but there's also from the tax side. I mean, if you're putting someone on title to your property, especially a child, I mean, that's the common scenario. You put a child on title, they live somewhere else. It's not their principal residence. It is your principal residence. You can claim a principal residence exemption for capital gains tax, whereas your child can't. And so you put a half interest in a child's name, 10 years passes, the property's gone up $1 million in value. It would have been exempt for you, but now there's capital gains tax for half of it. And that's not a great result. So it's generally better to get good advice around on the tax and legal side to make sure that when you're doing this, you've got the ownership structured properly.
Super. Thank you so much, Michael. I would like to thank all of you, Michael, Brandy, and David. Once again, you have been amazing. We had so many questions for you today, and you've answered them all clearly and beautifully. And we really appreciate all the time and energy and skill and knowledge that you're sharing with us today. Happy Make a Will Week, everybody. Hope that this has been an inspiring webinar to help you move to the next step that you'd like to take in terms of getting closer to having your will made. So thank you again. And I think with that, we will sign off for today. Thanks, everybody.
Thank you so much.
Thank you.
Thank you.
Thanks,
Have a
David.
good
Bye.
afternoon.
Thanks.